Proposed resolution by the Secretary for Labor and Welfare under the Protection of Wages on Insolvency Ordinance. Members who wish to speak, please press the Request to Speak button, and I'll call upon the Secretary to speak and move the motion. President, I move that the motion as printed on the agenda be passed. The purpose of the resolution is to raise the maximum amount of ex gratia payment on severance payment under the Protection of Wages on Insolvency Fund, the fund, so as to enhance the protection for employees of insolvent employers. The fund was set up in 1985 to provide timely financial relief in the form of ex gratia payment to employees of insolvent employers. The fund now covers areas of wages, wages in lieu of notice, severance payment, as well as pay for untaken annual leave and pay for untaken statutory holidays, subject to the respective payment ceilings. The fund is mainly financed by an annual levy on business registration. In June 2022, the fund raised the payment ceilings of various ex gratia payment items, including the severance payment from $50,000 plus 50% of excess entitlement to $100,000 plus 50% of excess entitlement. According to the application data by them, upon applying the revised payment ceiling, the percentage of applicants or applications for severance payment that could be fully covered by the fund was 78%. The government appreciates the concern of the public that upon the abolition of using the accrued benefits of employers' mandatory contributions under the Mandatory Provident Fund system to offset severance payment or long service payment, the abolition of offsetting arrangement, some employers may be unable to pay severance payment to employees. To enhance the protection of the rights of the employees affected by business closures upon the abolition of offsetting arrangement, the government has agreed to review again the coverage of ex gratia payment on severance payment under the fund to explore the room for further increasing its payment ceiling. The current review is also one of the policy initiatives in the Chief Executive's 2024 policy address. The Labor Department and the Protection of Wages on Insolvency Fund Board, the Fund Board, have completed the review. Having considered all relevant factors, the Fund Board proposed to raise the maximum amount of ex gratia payment on severance payment. I now introduce briefly the adjustment proposal in relation to the resolution. For the last review in 2022, the first part of severance payment ceilings was raised to $100,000 with fully covered rate at 78%. In the current review, if the first part of the severance ceiling is raised to $150,000, $180,000, or $200,000, the corresponding fully covered rates would be 77%, 83%, and 86% with reference to the information on applications received in 2023-24. To enhance the protection for employees, we propose to raise the severance payment ceiling to $200,000 plus 50% of excess entitlement, with a fully covered rate reaching 86%, which will be broadly on par with other claim items under the fund. As the abolition of offsetting arrangement will impact on the payout of ex gratia payment on severance payment, we do not recommend increasing the severance payment ceiling further to a higher level. For other payment items under the fund, including areas of wages, wages in lieu of notice, as well as pay for untaken annual leave and pay for untaken statutory holidays, with reference to the information on applications received in 2023-24, the fully covered rates are 86%, 91%, and 90% respectively. The fund provides the safety nets for employees. It does not mean to assume the liability of employers on payment of all wages and other termination compensation to their employees. We consider the level of existing payment ceilings on these payment items appropriate for protecting employees, and no adjustment is required at this stage. In the process of deliberation, the Fund Board has duly considered different economic scenarios and the possible impact of the abolition of offsetting arrangement on severance payment payable under the fund. As at end January 2025, the fund had an accumulated surplus of over $7.3 billion. Having regard to the robust financial position of the fund and the steady income of business registration levy, we consider that the proposal of increasing the severance ceiling will not adversely affect the sustainability of the fund. Adjustment to the levy rate of business registration to cope with the relevant payout is not necessary. The Labor Advisory Board and the Legislative Council panel on manpower have supported the above proposal. We propose that the new ceiling of ex gratia payment item on severance payment shall come into effect on the date on which the resolution is published in the Gazette. I hope that members will support and pass the resolution so as to provide better protection to the employees of insolvent employers as soon as possible. Thank you, President. And I propose the question to you that the Secretary's motion be passed. Mr. Lam Chen Sing.
Thank you, President. the government abolished the offsetting arrangement, and that is the reason why there is this amendment. I don't think there is a direct correlation between the two. However, I think that the government's move to increase the ex gratia payment for severance pay from 100,000 plus 50% of excess entitlement to 200,000 plus 50% of excess entitlement is welcome. Let's look at the balance of the fund. Currently, the balance stands at $7.3 billion. Every year, they collect more fees from business registration than what they pay out under the fund. The government talks about prudence in financial management, but there are a number of bankruptcy cases. In the CFA, there was a judicial review, and 2 years ago, there was a revision of the limit of coverage, the adjustments of business registration levy, as well as other revisions. None of these will have an impact on the government's finance. I think there is a conservative estimate of the state of the fund. During SARS, there was a number of 20,000 cases every year. I don't think that is a good estimate. The government admitted at that time there was abuse. Some companies wound up and applied for the fund to pay out the severance pay for severance pay. The fund itself is stopped as the ATM. These unscrupulous companies owners just opened another company. At that time, the commercial crime unit of the police cracked down on these cases. And since then, even with a poor economic situation, the number of cases under the fund does not exceed 20,000. The government should not use this as the estimate because it's an underestimation of the strength of the fund. Well, there is a cut on the transport concession. I think that given the surplus from business registration fees, more protection should be given to employees. Apart from severance pay, there are other items as well. Say, for example, the limit of areas of wages. I think it should be raised. There are cases when employees are owed close to $10,000, which is about 3 to 4 months of their wages. I think that the fund is in a favorable position to have the amount increased. The arrears of MPF contribution should be included under the fund as well. If the ex gratia payment is about $100 million, even given the amount, the payout will be about $7 billion, about $5 million at 5%. So I think that the scope of the fund should cover employer contribution towards the MPF. There is no set review time of the ex gratia payment amount. It seems that the review is rather arbitrary. For some items, it's been over 20 years since it was last reviewed. However, since the revision in 2022, there is another revision in 3 years' time. I suggest that the Labor Department and the board should conduct a review once every 3 years, looking at the financial situation and the changes in wages. Then consider whether better protection should be given to employees. I speak to support the resolution. Mr. Dennis Leung. The revision of a scope of the severance pay was discussed in a panel back in 2024. We looked at the suggestion. Similar suggestion was also discussed The relevant amendment came into operation in 2022. It covered areas of wages. The fully covered rate increased from 66% to 90%. Payment in lieu was increased to $45,000. Covered rate increased to 90%. Severance pay increased to first $100,000 plus 50%, with a fully covered rate increased to 78%. And pay for untaken annual leave and untaken statutory holiday, it was increased to $26,000, with a fully covered rate raised from 74% to 93%. The fully covered rate for severance pay was 78%, not as high as the other items, that is over 90%. I'm happy to learn that the government has responded to the voice to offset the offsetting arrangement. As a result of this move, some employers may not be able to pay severance pay. The government then conducted a review on the maximum amount of ex gratia payment to better protect the rights of employees. And this is one of the initiatives in the policy address. The maximum amount of this item is increased to $200,000 plus 50% of excess entitlement. Information of cases handled by the fund in 23 and 24 suggests that the fully covered rate will drop by half. For the first amount to be increased to $200,000, looking at the number of cases in 23 and 24, the fully covered rate will be increased to 86%, an increase by 8%. The government reckons that the annual payout will be $23 million. Given the current financial situation, there is still a surplus in the fund, so the proposal can be supported. The fund will only see a loss when there is a financial downturn. The panel on financial services was consulted. The advisory board was consulted as well. All members support this proposal. I ask members to support this proposed resolution to afford better protection to employees. Well, the fund itself is heavily related to the various items, say ex gratia payment. I would like to add this point. I see that there is information on the website of the Labor Department. This is to enhance transparency on rights and benefits. There was an exhibition from the 19th of March to the 21st of March. The information covers labor information, on the legislation on the Employees Ordinance, domestic helpers legislation, as well as information about the fund. I hope that the change will not be untimely, because this will affect employees' benefits. Well, if employers don't understand, please contact the FTU or Labor Department. Please stay put. That is the best strategy. Mr. Bill Tang. I want to elaborate on 2 points. The first one, well, this proposal to revise the item is a result of the abolition of the offsetting arrangement. At that time, the employers were asked to make an additional 1% into a pool to handle increased cost after the abolition of the offsetting arrangement. This time, the Secretary has changed their tactic. They propose to change the scope of the protection of wages on insolvency fund. I think it's a right move. I ask the government to continue its efforts, and employers should stay put. Do not fire anyone before the 1st of May. I'm a non-executive director of the MPFA. The current scope of the fund does not cover arrears of MPF. Say, for example, in September last year, there was the closure of physical. There are 700 employees. About $3 million of MPF was owed. There is no way for the employees to claim the amount. Other items are covered by the fund, but not MPF employer contribution. There are some other cases that is even more unreasonable. Employers take the 5% contribution from employees for other purposes. Again, there are no avenues to address the issue. I think it's a loophole. Now we have about $7 billion in the fund. With the revision of ex gratia payment on severance pay, I think the government can consider doing more in relation to employer contribution to the MPF. A good word. I've seen a number of reforms in the past. I heard about cases of closure of a business. Employees will have to apply for legal aid and then make a claim to wind up the business before they can start making applications under the fund. So from the closure to payment from the fund, it takes at least 5 to 6 months. And then there was a reform. The Labor Department will engage a lawyer to handle cases involving a large number of employees, say, for example, physical. In September, the business was closed, and in January, employees receive payout from the fund. So the time it takes is compressed to about 3 months. I think this is a very good example of reform. I asked the Secretary to continue with the good work and give protection to employees in relation to MPF contributions.
Mr. Leung Chung-hung, President, other members have mentioned what I want to say, but as a labor union representative, I need to say this. For the protection of wages on insolvency fund, the adjustments have always been, to a certain extent, regular, and consultations would be provided to employees. Should the company go into liquidation proceedings, the employees will be entitled to payment from the fund. The maximum amount of ex gratia payment on SP payable has been increased from 100,000 plus 50% of excess entitlement to 200,000 plus 50% of excess entitlement, and the coverage will now reach 86%. That is great. And I would say that the economy is somewhat resilient. With the pandemic as well as challenges from the West, we have recovered still. We have not seen large-scale layoffs. So the fund has always had a surplus. For those watching this right now, you may worry whether it would cause a deficit with the payment to the fund. But let me say this, it has always had a surplus, so this is not a concern. I would say this, with the new limit, if we are not faced with a tight fiscal position, we should include also unpaid MPF contributions as a category for payment out of the fund. With the abolition of the offsetting arrangement, we have seen many saying that there are often unpaid MPF contributions, or the employers would have plans not to make contributions to the MPF. And in fact, we have seen the bosses of companies taking away the mandatory contributions of employees as well. So it's worse than them just not paying their mandatory contributions. So those who have done these malicious moves will be prosecuted, but then we also want to offer protection to employees still, so that when there is insolvency, the payment of the fund can also cover unpaid MPF contributions. I speak in support of the proposed resolution. Thank you. Mr. Chiu Ka-fai. Raising the maximum amount of ex gratia payment under the fund, I would not object to that. But I need to remind the Secretary that recently we have seen the fund growing in size. But whether it can actually support the payments. In fact, before we have MPF, many companies would go bust. And before there's no MPF, so people would not be paid severance payment, and that can be very debilitating for employees. We now have much funds locked with MPF, so employees will not be as affected these days. And you can see in the end, companies may actually suffer because of this. When we have a fund of a size of $7 billion, we need to rethink this arrangement. Employers' 5% mandatory contributions are not made to MPF accounts. They are just on the company accounts, and when employees retire, they can get the funds. However, when some black sheep do things maliciously, it can be a problem. So there are employees who would work for some years, and if companies can be entitled to such funds, instead they can revive their business if their business is not doing well, and it actually benefits employees even more instead of having to shut down their business and make use of the PWIF. The reserves of the fund is quite large in size, but when something like this happens, we need to think about what is going to happen and what we're going to do. Does any other member wish to speak? Mr. Ko Wai-Kang. I speak in support of the proposed resolution because I think it would offer better protection for employees. We're raising the maximum amount of ex gratia payment on severance payment payable from $100,000 plus 50% of excess entitlement to $200,000 plus 50% of excess entitlement. It is not a great increase, but it will offer better protection. Mr. Shukafi talked about something that we should be concerned about. We have $7.3 billion in the fund. So we aren't too worried. With the abolition of the offsetting arrangement, we have not seen much need for payments out of the fund, but with the abolition of offsetting arrangement, the severance payments can get quite big, and there may be more payments needed from the fund. I hope the government can plan in advance to see where the safety net is. So whether the $7.3 billion is actually enough, we need to really consider that. Second, in the short term, with the fund being quite stable, we should increase coverage. As some members said, unpaid MPF contributions or employers misappropriating employees' mandatory contributions these have happened before, and employees are faced with no options to recover such amounts, and the MPFA cannot do anything anyway. Are employees really left with no options, or should we pay the employees what they earned out of this fund? The PWIF would protect employees with regard to the relevant payments, but then because MPF is another source, there is no coverage at all. Is that really the right way to go? Also, as other members said, with the abolition of the offsetting arrangement, we really need to think about how we can protect also digital platform workers. Some regard them as self-employed persons and therefore not entitled to protection. But the problem is when the companies they work for go bust, they are left with no options. It would be hard for them to go through the small claims tribunal or the labor tribunal either. Can we do more in providing protection to them if they are faced with wages in arrears? Can we pay them out of the fund to offer better protection? I so submit.
Does any other member wish to speak? If not, I now call upon the Secretary for Labor and Welfare to reply. Then the debate will come to a close. Secretary. President, I thank the 6 members for speaking on this resolution. I will make a simple reply. A lot of members ask if we can expand the scope of PWIF to cover arrears of MPF contributions. I wonder if they're talking about the employer's 5% contribution or the employee's contribution. When we established the PWIF to provide financial relief in the form of ex gratia payment of insolvent employers. They're about ex gratia payment arrears of wages. The reason why we have the PWIF is to offer financial relief. If you don't have this safety net, then the employees have no means to live and to care for their families. The PWIF has been effective over the years to provide financial relief for employees who were unable to get the wages that they were entitled to from the employers. For MPF, we're talking about retirement. We have to think about it, but should we solve this issue by adjusting the scope of PWIF? We have to be careful. I cannot give you a solid reply today. I know that you want us to think about whether we should adjust the scope, but we have to think about the relationship between MPF and the PWIF. The financial position of the PWIF is robust, but when we make any adjustment, we have to look at the long-term implications. After abolishing the offsetting arrangement, it will definitely affect the fiscal position of the PWIF. We have to be cautious. We look out for the interest of the employees. After increasing the payment ceiling for a number of items in 2022, we have raised the amount another time in 2025 in order to enhance the coverage rate. The fully covered rate is now some 85% for a lot of the items under the PWIF. This is a great protection for the employees. I thank the members for their support, and I appeal to members to support the resolution so that we can raise the ceiling amount for the ex gratia payment for better protection. I now put the question to you that the Secretary motion be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed.
議員就附屬